Of them is local standi. Currently, there are two approaches to local standi. One is the narrow view, and one is the liberal view. Our judge, Datuk David Wong, has adopted the liberal view. All right. Basically, he's saying the native of Sabah, particularly in this case, who feels that the government has failed to implement the assurance and the undertakings referred to in the Malaysia Agreement, has the right to come to court for the court to decide or to adjudicate whether the government has failed to implement those undertakings and assurances. The other ground is privity of contract. The government say that because the parties to the Malaysia agreements are the government and not Najib and Bernard, so the proper person to sue should be the state government. But the judge disagree and thinks that the government are the trustee of the people and the people are the beneficiary of the Malaysia agreement. So the people has the right to go to court and should not be deemed that they are not the party to the agreement, see, Malaysia agreement. And there are other issues like non-justiciability. The court also disagree with the contention of the state and federal government that whether or not the issue of the government failing to implement the Borneonisation program cannot be decided by the court. The court believed that our judge believed that the court has the power to decide this issue. As for the declarations that are vague, the court doesn't agree with the federal council and the state council, because the court thinks that the declarations sought by Mr. Najib and Mr. Bernard Fung are triable. Okay, whether the Borneonisation program has been implemented is triable. It's not vague at all. Whether what we are asking for is scandalous, frivolous, or vexatious, okay, the court also disagree with them, because the court says that what we are asking for is actually not for reinstatement of Bernard Fung and Najib to their position. The declaration we ask for is generally for the public, just to say that the government has failed to implement the Borneonisation program. So it is not scandalous, frivolous, or vexatious. And then as to whether we have filed this application within limitation, the court also says that we are not time barred. The court quoted one court of appeal case. I didn't get it, but it's just that we are not time barred, you know. And the court I think what Datuk David Wong say is whether there is a time bar or not is academic. The court should actually deal with issues if these are real grievances. No useful relief is the same. Actually, the court also disagree with that. Now, whether we have enough evidence, okay, to prove that the government has failed to implement the Borneonisation program, the judge say this is best left for the hearing proper, you know. At this juncture, it is not suitable to determine that issue. If we have not enough evidence later on during the hearing proper, then the court may not grant our declaration. So we have to prove that the government has failed to implement the Borneonisation program. And then lastly, the federal government say we should go under judicial review, Order 53. And the court actually say we don't have to. If we can just go to court and seek declaration by way of this application. Okay, the judicial review is actually to quash certain decision by the government. There is no decision by the government at this stage. It is just our allegation to say that the government has failed to implement the program. So judicial review is not suitable. So with that, the court disallowed the application to strike out by both the government, state government and federal government, and fixed a mention for the two defendants to file their affidavits later on, okay, and then to fix hearing proper.